I told my client to take the offer. She said no. I said, I'm telling you, this is the best offer you're going to get, and it is my recommendation that you should accept this substantial offer. She said no. You want to know what happened after that? Come join me for a walk near the marina as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. This is a medical malpractice case, and now she suffered significant harm and injury as a result of a doctor's carelessness. It was now 3 years into the litigation, and the defense came to us and said, listen, we'd like to start negotiating. And over the next couple of weeks, we now reached a point where the defense turned around and had offered a very substantial amount of money, into the 7 figures. And now, it was my recommendation to my client that she go ahead and accept the offer. My client said, no, I'm not taking the offer. I need much more. I said, this is the best that you are going to achieve from any type of voluntary settlement. This is guaranteed money if you accept this right now. There is no question about whether you will receive this. You will get this money. It is guaranteed. She said, no, I need much more. So I turned around and I said, and I rarely do this, because she was so frustrating, because every single offer that I presented to her, she simply said no to. She didn't say what she wanted. She simply said no. With the first offer I told her about, which I recommended that we not accept, she said absolutely not. When I came back with the second offer, she said no. Every single offer I presented to her, it was no, no, no. Her answers were always no, no, no. And it was getting very frustrating because she would not give me an answer as to what she wanted. So finally, and I rarely, if ever, do this, I turned to her and I said, what exactly is it that you want? Because the only thing that we can achieve in this particular case is to obtain money for you. I can't put the pieces back together. The doctors have not been able to put the pieces back together to make you whole again, to turn back the clocks of time so that you are now the same person you were before this whole event occurred. I can't do it. Your treating doctors can't do it. The doctor whom you've sued, the doctor whom you once trusted and loved, can't do it. So what is it that you want from me that's going to end this lawsuit and this litigation? Nope, I will not do it. I want to go to trial. And at trial, what is it that you want a jury to do? I want the jury to hear my story. I want the jury to understand what happened to me. I want the jury to know, and I want the world to know, what this doctor did to me. I said, that's all well and good. But first of all, this doctor did not intentionally cause you harm. So put that to bed, because that argument doesn't fly, and no jury is going to recognize that, as much as you might think that. This doctor did not wake up in the morning and say, hey, how can I harm this patient today? That's not what happened, and that's not what any jury would ever accept. So put that away. With the first offer I told her about, which I recommended that we not accept, she said absolutely not. When I came back with the second offer, she said no. Every single offer I presented to her, it was no, no, no. Her answers were always no, no, no. And it was getting very frustrating because she would not give me an answer as to what she wanted. So finally, and I rarely, if ever, do this, I turned to her and I said, what exactly is it that you want? Because the only thing that we can achieve in this particular case is to obtain money for you. I can't put the pieces back together. The doctors have not been able to put the pieces back together to make you whole again, to turn back the clocks of time so that you are now the same person you were before this whole event occurred. I can't do it. Your treating doctors can't do it. The doctor whom you've sued, the doctor whom you once trusted and loved, can't do it. So what is it that you want from me that's going to end this lawsuit and this litigation? Nope, I will not do it. I want to go to trial. And at trial, what is it that you want a jury to do? I want the jury to hear my story. I want the jury to understand what happened to me. I want the jury to know, and I want the world to know, what this doctor did to me. I said, that's all well and good. But first of all, this doctor did not intentionally cause you harm. So put that to bed, because that argument doesn't fly, and no jury is going to recognize that, as much as you might think that. This doctor did not wake up in the morning and say, hey, how can I harm this patient today? That's not what happened, and that's not what any jury would ever accept. So put that away. So I then said, what is it that you want the jury to know? She wanted to tell her story to the jury. She wanted them to understand what she went through. She wanted them to recognize all the suffering and the pain and the limitations and the disability that she had to endure because of this doctor's carelessness. I said, once they do that, what is it that you want them to do? She said, I want them to give me proper compensation. And now here's the kicker. And I said, what is proper compensation for you for all of these harms and losses and damages? And you know what she said to me? I don't know. I said, that's exactly the point. You don't know. You don't know what other similar cases have settled for. You don't know what other similar cases have gone to verdict for and then gone up on appeal and been upheld or rejected or thrown out. You don't know the answer. And now I explained to her that we've had many conversations about the risks of going to trial, about the risks of accepting a settlement. And by the way, there are risks of accepting a settlement. And one of those risks involves regret by turning around a year, 2 years, 5 years down the road saying, you know what? I should have gone to trial, or I should have held out for more. So there are risks of that as well. But she didn't really know what exactly it was that she wanted the jury to do. And yes, she wanted to be heard. She wanted a voice. She wanted the ability to express herself and to tell someone besides me about all the trauma and all the horrible things she had to endure. And that was understandable. What was not understandable of what's actually involved in valuing her type of injury. And I said to her again, I said, listen, all the case law that I have seen, all the prior settlements that I am aware of, now, your injuries are in excess of many of these cases. And as a result, the defense has now made a substantial offer, clearly far in excess of any of these other cases that I have seen that I presented them with. And they recognize that. And as a result, that is why they are willing to negotiate and to offer such a substantial amount of money. For you to turn around and reject this money, here's what is likely going to happen. You will now force us to go to trial. And I have no problem going to trial, but I'm going to tell you what could and may likely happen. When we go to trial, there is the possibility that no matter what happened to you, no matter how great our experts are, a jury may not like you, they may not like me, they may not like our experts or our other witnesses. And as a result, they may reject all of our claims and throw you out of court before they even answer the question of what your injuries are worth. And you know what she said to me? She said, that's impossible. I said, no, it is not impossible. It happens every single day. The jury may come to their conclusion that the doctor did absolutely nothing wrong, because that's the first question they have to answer, whether the doctor departed from the standard of care. If they feel that the doctor did not depart from the standard of care, there was no carelessness, there was no wrongdoing, guess what? You lose. You're done. And all these years of litigation and refusing these settlement offers, they're now out the window, and you walk home with zero. Absolutely nothing. If the jury comes back and says, you know what, we agree with you, Mrs. Jones. We do believe that the doctor was careless. However, we don't believe that his carelessness was a cause of your injury. And you say, that's impossible. And I respond, oh no, that is not impossible. That can easily happen. The jury may feel, yes, the doctor was careless, but his carelessness did not cause you harm and injury. In that instance, guess what? Your case is over and you get absolutely nothing. And you say, that can't be. I said, yes, that can be, and it certainly can happen. On the other hand, the jury could come back and say, you know what? Yes, the doctor was careless. Yes, his carelessness caused you harm and injury. Now, the jury gets to evaluate your injuries. They get to put a value on the extent of your injuries and determine how much money you are to receive. And guess what? The jury might determine that your injuries are not worth anywhere near what we believe them to be. And now the jury concludes that you are not entitled to receive the substantial amount that you may think you're entitled to. In fact, they offer you a fraction of what you have been offered in settlement. And you say, that's impossible. And guess what I respond? No, that is not impossible. In fact, that happens more often than we'd like to see, where the jury concludes that your injuries really are not worth what you claim them to be. In that instance, you are now in a very tough predicament, because now you have very little choice. You can ask the judge to go ahead and increase the amount the jury gave you. We can now ask the judge to throw out the verdict. We can then go up on appeal if there are grounds for it. We can now ask the appellate court for a new trial on damages. And there could be many outcomes, uncertain outcomes, of what actually is going to occur. And you say, that's impossible. I know based upon my injuries that a jury is going to see it my way, and they're going to recognize that my injuries are worth 10 times easily what the defense has offered. And I said, that may be true. However, if that happens, here's what's going to occur. As soon as that happens, the defense attorney is going to jump up out of his seat as if an ejection button was pressed and yell out, "Objection, Judge! I ask that you throw out Oginski's client's case as being against the weight of the evidence." And there's a legal phrase for that called judgment non obstante verdicto. It's known as a JNOV. And all that means is that says, Judge, there is no possible way the jury could have reached this conclusion because the evidence doesn't support it. So please throw this out before we go any further. And it is possible that the judge could in fact agree with the defense attorney and throw it out. On the other hand, the judge could say, you know what? You go ahead and take an appeal, Oginski. You take an appeal and see if you can overturn this verdict or have it changed. And now we are stuck with having to deal with an appeal, assuming there are grounds for appeal, which could take another 1 to 2 years. And even then, there's no guarantee on any particular outcome. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand what happened in this one particular case, where this one injured patient kept saying no, no, no to these very substantial settlement offers that I recommended, and she absolutely refused. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.